Mayong buntag, naimbag na malem, mayap abeni, magandang buhay everyone! I, together with my warrior classmates, are gladly to welcome everyone to our second law on the subject of legal aspects in tourism and hospitality. The Labor Code of the Philippines outlines the laws that regulate the employment practices and labor relations in the country, comprising the prescribed rules for hiring and termination of private employees, as well as the working condition, including the maximum hours and overtime, employee benefits such as the holiday pay, retirement pay, 13th month pay, and the salary. The protocols in organization and membership in labor unions as well as in collective bargaining. To start and to further discuss the labor law, the floor is yours, Ian.
Learners are one of the special group of workers written in Chapter 2, Article 73 to 77 of the Labor Codes of the Philippines. Learners are people recruited as trainees in semi-skilled and other modern occupations which are not apprenticeshable and which might be learned through pragmatic preparation at work in a somewhat brief time frame which will not surpass 3 months. Learners may be employed when no experienced workers are available. When employing learners is necessary to avoid job loss, and when employing learners does not cause unfair labor cost competition or impair or decrease working standards. Here's Jed to discuss what is regular employment.
What is regular employment? According to Article 280 of the Labor Code, regular employment refers to that arrangement whereby the employee has been engaged to perform activities which are usually necessary or desirable in the usual business or trade of the employer. The primary standard that determines regular employment is the reasonable connection between the particular activity performed by the employee and the usual business or trade of the employer. The emphasis is on the necessity or desirability of the employee's activity. They enjoy the benefit of security of tenure provided by the Philippines Constitution and cannot be terminated for causes other than those provided by law and only after due process is given to them. Thus, when the employee performs activities considered necessary and desirable to the overall business scheme of the employer, the law regards the employee as regular. However, some employers can require their new employees to undergo probationary employment before they can be qualified for regular employment. Under Article 281 of the Labor Code of the Philippines, the maximum length of probationary employment shall be 6 months and is counted from the date an employee started working. When the employment is not terminated after the 6 months probationary period, it shall be considered regular employment. To discuss contractual employment, we have Miss Debbie.
Hello everyone! Let's now proceed to the contractual employment. Contractual employment, it requires people to sign and agree to the terms of the contract of his or her chosen company before starting the work. The contract is between the employee and an employer. Contract work provides an additional experience, knowledge, and also skills. Contract work will give you an opportunity to work in different industries with a short period of time. The contract ends before 6 months. To discuss seasonal employment, we have Miss Kim.
Thank you, Ms. Debs. Seasonal employment is a kind of employment arrangement where an employer hires an employee to meet the temporary needs of an organization. Hiring a seasonal workers can be a convenient way to cover an employees who are absent. They are not an official employees of an organization. They are like part-timers where they only work for a week up to several months. They are not included in a year-round position. Example of this is ski resorts. They only open in mid-October up to April, so every year, they hire new employees. That's all for the seasonal employment. The next topic is the fixed-term employment, which will be discussed by Phil.
Hello everyone! In this video, I will be sharing to you what is fixed-term employment and casual employment. So for the fixed-term employment, it is a contract in which company or enterprise hires an employee for the specific period of time. In most cases, it is for a year, but it can be renewed after the term expires depending on the requirements. And in a fixed-term employment, the employee is not the payroll of the company. So let's proceed to the casual employment. Casual employment is a practice of hiring employees on an as basis to meet companies' staffing needs during peak business period. In casual employment, practice employees' service can be terminated without notice. So that's all for today. Thank you for watching. Bye!
Now, let us differentiate job contracting and labor-only contracting. Firstly, we have job contracting. In here, the principal, which is the owner, has an agreement with the contractor or subcontractor to complete any project, work, activity, and others. For example, we have a logistics company. This company wants to create another warehouse, so they had an agreement with the contractor to build it. In job contracting, the contractor must have a sufficient capital. That means a capital or a net worth of at least 5 million, or investment that refers to the equipment and tools needed to fulfill the contract. The principal will pay the contractor, and in return, the contractor will be providing or taking care of all the needed things like the construction materials, equipment, tools, and even the labor force. So, the people hired to do the job are employees of the contractor, not the principal or the owner. The contractor is responsible for paying the hired people as well as giving the benefits in accordance to the law. Now, what is labor-only contracting? This is when the contractor would only hire people. That's the only thing that they would do. The providing of tools and equipment, the supervision, the paying of people, and other necessary things to consider are done by the principal or owner. Meaning, the hired people are their employees, not of the contractor. Now with this, labor-only contracting is prohibited by the labor code while the other one, the job contracting, is legal. Here's a question. What if it's considered as job contracting but the employees were not paid by the contractor? Then the employees could go directly to the principal. I hope this gave you an additional knowledge. Now here's Jack to discuss the powers of an employer.
Power of employers. There are 3 classifications of these, but before that, I will define employer first. Employer is an individual or organization that has employees. It can direct the work of employees, including dictating where, when, and how work is completed. The first power of employer is to hire. They can select who will be their employees based on your qualities and especially your looks. Second, to control. Control in the sense of working and especially in the payment of salary or wages. Last power of employer is to fire. Here we have 3-letter rules. But before that, do not fire an employee using electronic method. No emails, IMS, voicemails, or phone calls. Even a letter is inappropriate when you fire an employee. When you fire an employee, give them a courtesy that you would extend to any human being. Now first, you should know or you need to be informed by the violation of your employee. Second, you need to know how to answer or how to make a move to that. And last, make a wise decision. Remember, wise decision. Here to consider is be professional, be concise, and be honest. To discuss causes of termination, here's Donna.
As we all know, the Labor Code of the Philippines has a number of several provisions that benefits the workers. It prohibits the termination from employment of private employees except for just and authorized causes that is being prescribed in Article 282 to 284 of the Code. In clarifying the termination of employment, let's have first a discussion of just causes termination. According to Article 282 of the Labor Code, an employer can terminate an employee for just causes pertaining to: first, serious misconduct. Focus on an employee's improper activity that might endanger the company's reputation or productivity. Second, willful disobedience. It is important to have an established guidelines and restrictions in the workplace. Thus, these protocols must be legal and acceptable, and they must be known and harmonized with the duties that employees are responsible for. Third, gross and habitual neglect of duties. It is focused to a repeated failure to perform one's duties. Fourth is the fraud or breach of trust. And fifth is a commission of a crime or offense against the employer, his family or representative, and any other similar causes which covers all the unacceptable norms in the workplace which can result to a threat to the business and the employment relationship. In other words, just causes termination is all about the neglectful acts of the employee. It means that they are just to be terminated for their work, but of course with providing a valid and legal offense in practicing the due process of law before terminating one's employment by creating the two-notice rule. First, the company must provide a written notice comprising to explain what was violated for termination and giving an employee a chance to explain their side with enough time. On the other hand, they are also allowing the employee to have a conference or hearing to respond, present evidences, or to rebut the evidences presented against them. And second, the final step, which comprises a notice of final decision indicating the grounds or basis for termination as well as the corresponding sanctions, if any, after due consideration of all evidence. In short, just causes are the reasons why employees are being terminated because of their own fault or violation. Thus, they are not allowed to have a separation pay unlike the authorized causes. In that, here is Irish to further explain the authorized causes of termination.
Thank you, Ms. Donna. So, if an employee can be terminated due to his or her own causes, according to the Book 6 Post-Employment Article number 283, titled Closure of Establishment and Reduction of Personnel, the employer may also terminate the employment of any employee due to the business reason, specifically, first, the installation of labor-saving devices. It means there will be a decrease in the number of employees due to the new introduction of machinery, equipment, or any other devices. The company have been authorized to install labor-saving devices to, of course, save on costs, enhance their efficiency, and any justifiable economic reasons. Second is redundancy. It exists if there is an excessive position or service of the employee that does not necessarily needed in the company. Third is retrenchment. It is a downsizing of job employment to prevent the company from occurring losses as well as the company's dissolution. An example of this is some airline companies decreased their number of employees due to the pandemic. As we all know, the government restricted to travel internationally and domestically since we are constricted with lockdown and the rapid increase of COVID-19 positive cases here in our country. Moreover, the employer may also terminate the employment of employee found experiencing any disease. Nevertheless, if terminated, the employee should receive any separation pay that at least 1 month of his pay. Furthermore, the company should submit any written notice of dismissal to the Department of Labor and Employment and to the employee 30 days before termination. To discuss about the rights of human employment, specifically the security of tenure, here's Ms. Ian.
Security security of tenure. Every employee shall be assured security of tenure. No employee can be dismissed from work except for a just or authorized cause and only after due process, meaning they cannot be terminated when the employee is under a fixed contract. Next is work days and work hours that will be discussed by Mix.
Work is necessary on regular basis. The term work hours refers to the total number of hours spent on the job. According to Article 83 of Labor Code, an employee usually working hours cannot exceed 8 hours per day. This excludes the 1-hour lunch break. Break time is normally 15 minutes. It happens between 4 hours of your work. Overtime is the excess of your 8 hours of work. If this happens, you may have overtime pay, which is higher than your regular salary. Undertime is the lack of expected hours to the work within the time or the day, and your salary will be paid undertime. Always remember, if someone told to you to work 2 hours since you are late, it cannot be happen. It is different to pay overtime and deducting your undertime. Workdays is the 5 days per week, except for the need of service such as personal work for 6 days or the 48 hours. If this happens, they will have additional compensation of at least 30% of their regular salary for work on the 6th day. Next reporter will be MG to discuss what is weekly rest day.
Having a job is part of every human's life. Being an employee is a process and a choice where we let ourselves enjoy the day when we can have a rest or free time for ourselves just like everyone else. Lots of employees love a weekly rest day. Sometimes they can't wait until the day when they will allow themselves to re-energize and protect their health, either physical or mental, after a whole week of working. As we all know, a weekly rest day is a day off of 24 consecutive hours after 6 days of work. It shall be the duty of every employer, whether operating for profit or not, to provide each of the employees a rest day. And when we say rest day, it is not automatically Sunday because the law never specified a specific day. It depends on the religious practices and preferences of employees. But of course, the employers try to designate Sunday as a weekly rest day. To discuss the payment of wages, here's Aya.
Hi everyone, my name is Aya and I'm here to discuss the payment of wages. The term wage means the remuneration or earnings payable by an employer to his or her employees under a certain written or oral contract of employment for work done or to be done. Wages must be paid at least once a month and can also be paid once every 2 weeks or twice a month at intervals not exceeding 16 days. It must also be paid in cash or legal tenders such as banknotes. That's all for payment of wages. Next topic will be discussed by Miss Gia.
Employment of women. Women and men bring different skills and perspective to the workplace, including different attitudes to risk and collaboration. And here in the Philippines, the rate of employment of women is 93.5%, higher than the employment of men, which is 93.0%. The productivity and growth are increased because the woman brings additional skills to the workplace, and the productivity and growth advantages from increasing involvement in the labor force. Additional, not all women cannot do the work of men, and not all men can do the work of women. That's all about employment of women. To discuss about the employment of children, here's Ayeng.
In accordance with Article 8, Section 12 of the Republic Act Number 7610, otherwise known as the Special Protection of Children Against Child Abuse, Exploitation, and Discrimination Act, amended by the Republic Act Number 7658, and further amended by the Republic Act Number 9231, children below 15 years of age shall not be employed except first, when the child works directly under the sole responsibility of his or her parents or legal guardian, and where only members of his or her family are the employees. However, it should assure that his or her employment does not endanger his or her life, safety, health, and morals, nor impairs his or her normal development. Additionally, the parents or the legal guardian shall provide the child with prescribed primary and or secondary education. Second, when the child's employment or participation is essentially required in public entertainment and information through cinema, theater, radio, television, and other form of media, provided that the employment contract is concluded by the parents or legal guardian of the said child with his or her express agreement. If possible, and the approval of the Department of Labor and Employment. Child's work in public entertainment and information is allowed as long as they complies to the said or to the following requirements. In the set of exceptional cases where any such child may be employed, the employer shall first secure, before engaging the child, a work permit from the Department of Labor and Employment, which shall ensure that the observance of the following requirements. For the purpose of this article, the term child shall apply to all persons under 18 years of age. To discuss the safety working condition, here's Ms. Donna.
For the 7th rights of human employment, safe working conditions, employees' health, safety, and social welfare benefits must be provided in the workplace. It serves as a protection for essential services such as medical treatment, rehabilitation, and hospitalization. It also includes the sickness. Sickness means any illness that being accepted as an occupational disease listed by the Commission or any other illness caused by work. It also includes the death, disability, accidents or incidents, and it also includes the drug-free workplace and the training and the education for the employees and etc. Additionally, Social Security System or SSS and Philippine Health Insurance Corporation or PhilHealth are those insurances that are being withdrawn or deducted from the salary for the utilization in the event of emergency that may occur. In light of all that I've said, in order to have a safe and healthy working environment, every employer must encourage the strict but progressive and participatory implementation of occupational safety and health rules. To discuss the right of self-organization and collective bargaining, the floor is yours, Andrea.
What is the right to self-organization and collective bargaining? Workers and employees have the right to form, join or assist labor unions, organizations, or associations for the purposes of collective bargaining, negotiation, mutual aid, and protection. It also refers to the right to peacefully organize and participate in policy and decision-making processes that affect their rights and benefits. To discuss the benefits for work-related contingencies, take it away, Leica.
Republic Act 8187. According to Section 1, this act shall be known and cited as the Paternity Leave Act of 1996. According to Section 2, RA 8187 is an act granting paternity leave of 7 days with full pay to all married employees in the private and public sectors for the first 4 deliveries of the legitimate spouse with whom he is cohabiting and for other purposes. In accordance with Section 5, any person, corporation, trust, firm, partnership, association, or entity found violating this act or the rules and regulations promulgated thereunder shall be punished by a fine not exceeding 25,000 pesos or imprisonment of not less than 30 days nor more than 6 months. And we also have the Republic Act number 11,210. According to Section 1, this act shall be known and cited as the 105-day expanded maternity leave law. This is an act increasing the maternity leave period to 105 days for female workers with an option to extend for an additional 30 days without pay, and granting an additional 15 days for solo mothers. Pursuant to the Republic Act number 11,210, grants of maternity leave are as follows. Maternity leave for female workers in the public sector and the private sector. Maternity leave for women regardless of civil status. We also have maternity leave with pay in case of childbirth, miscarriage, or emergency termination of pregnancy after the termination of an employee's service, and a lot more. Let's now move on to the next topic. Ms. Adi Barreto, the floor is yours.
Working for a company, employer, or client should always be requited. There are 3 different kinds of income an employee receives on specific or basic days: the holiday pay, the overtime pay, and the regular pay. First, the holiday pay is a form of alternative compensation an employer offers employees during the holidays. It can either be fully or partially paid time off or additional hourly pay for work done during the holidays. For any unworked regular holiday, 100% of the employee's daily wage rate. And for work performed on regular holidays is given 200% of an employee's daily wage rate, which is termed as double pay. Next, the regular pay is the base amount paid a non-exempt employee on an hourly basis. It's the recurring pattern of pay for an employee while working his regular hours of work. The examples of pay wages in different regions will be displayed on the screen. Lastly, overtime pay. It refers to the additional pay for work performed in excess of 8 hours a day, plus 25% of the hourly rate for work performed in excess of 8 hours a day on an ordinary day, plus 30% of the hourly rate for work performed in excess of 8 hours a day on a rest day, special day, or a regular holiday. That is it for this topic. Next up is Danny, who will talk about the Social Security Act of 2018 and the National Health Insurance of 1995.
Social Security System and National Health Insurance. First, the Republic Act number 11199, Social Security Act of 2018. An act rationalizing and expanding the powers and duties of the Social Security Commission to ensure the long-term viability of the Social Security system. Repealing for the purpose Republic Act number 1161 as amended by Republic Act number 8282, otherwise known as the Social Security Act of 1997. According to Section 2, Declaration of Policy, it is the policy of the state to establish, develop, promote, and perfect a sound and viable tax-exempt social security system suitable to the needs of the people throughout the Philippines, which shall promote social justice through savings and ensure meaningful social security protection to members and their beneficiaries against the hazards of disability, sickness, maternity, old age, death, and other contingency resulting in loss of income or financial burden. Second, National Health Insurance Republic Act No. 7875, National Health Insurance Act of 1995, an act instituting a national health insurance program for all Filipinos and establishing the Philippine Health Insurance Corporation for the purpose. The program aims to provide health insurance coverage and ensures access to cost-effective and quality health care services for all Filipinos who are qualified as dependents. Qualified dependents must be declared by the principal member. Their names must be listed under the principal member's member data record or the MDR. To finally end this video, here's Donna.
So, why do we need to know this law? Basically, the importance of labor law in regards to the world's largest industry, the tourism and hospitality, in accordance to Article 3, Bill of Rights, Section 1 of the 1987 Constitution of the Republic of the Philippines, no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. Thus, labor includes to the word property. Every employee must be able to own his work. As a result, it is important for the employee to understand and be informed of their rights to defend themselves, and for the employers to be aware of the employment circumstances. Additionally, the employer-to-employee relationship is a must. We may find it crucial, yes, right? But it is better to be informed and knowledgeable of this kind of law. I hope you enjoyed this video and learned something from us. Tandaan, lagi nga sinasabi ni Kuya Kim, iba ang may alam. Don't hesitate to give us a thumbs up, subscribe this channel, and click the notification bell to keep you updated on our next video. Goodbye!